provided by the Constitution, the SEC only wins about 58% of its cases. And between fiscal year 2011 and 2014, the SEC, however, won an average of 90% of its cases in front of ALJs. The FTC, who you went up against, wins not over 90% of its cases before its own ALJs. Yet Lena Khan, who was the head of the FTC under the last administration, lost almost every single case she ever brought before an Article III case, or an Article III court. When Axon was forced into the FTC Administrative Law Court, or ALC, proceedings, were you provided with the same protections and rights you would expect in an Article III court, such as due process, the right to a trial by jury, that sort of thing?
Absolutely not. No, it was a foregone conclusion. Frankly, it was described to me by my attorneys as hopeless. There was a 0% chance over the previous 20 years of getting a fair trial.
What you just watched is exactly why moments like this matter. Welcome back to Congress Lens. I'm Audrey, and today we're breaking down Representative Harriet Hageman pushing back after a witness floated the idea of articles of impeachment against President Trump over alleged court defiance. Right from the start, what stood out to me was not just the impeachment talk. It was the framing. The suggestion that we are somehow already on the brink of a constitutional crisis, while ignoring serious constitutional concerns that happened under the previous administration. And that's where Harriet Hageman stepped in. This was not noise. It was not random outrage. It was a sharp redirect to something a lot of Americans actually care about: selective outrage, unelected bureaucratic power, and whether everyday citizens truly get a fair shot in administrative courts. We are going to break all of that down. Before we jump in, make sure you like this video, subscribe to Congress Lens, and drop a comment below. Do you think administrative courts give Americans a fair chance against federal agencies? Let's get into it.
Chairman, Professor Vladeck, while the Republican majorities in the House and Senate stand aside and do nothing to stop the Trump administration's incursions on congressional authority, the courts have begun to step in and block some of these unlawful actions. But not content merely to undermine congressional authority, in the face of these court decisions, senior administration officials have now tried to question the legitimacy of the courts themselves. For example, in response to a court order blocking Elon Musk from accessing sensitive Treasury Department data, Musk said that the judge who made the ruling, quote, needs to be impeached now. Vice President J.D. Vance stated that, quote, judges aren't allowed to control the executive's legitimate power. President Trump said, quote, no judge should frankly be allowed to make that kind of decision. It's a disgrace. The White House called the judgment absurd and judicial overreach. And now these vague threats to judicial independence have seemingly crossed the line into actual defiance of a court order. Yesterday, a federal judge in Rhode Island ruled that the White House had defied his order to unfreeze billions of dollars in federal grants. Can you describe the constitutional crisis we would face if the Trump administration continues to ignore valid court orders?
Sure. I think, Congressman, we've never seen a crisis quite of that scope. I mean, the famous quote about Andrew Jackson and John Marshall is apocryphal. Andrew Jackson actually did not frustrate the Supreme Court's decision in Worcester versus Georgia. The only example we have of a president ever openly defying a decision by a justice was Lincoln at the outset of the Civil War, refusing to comply with the writ of habeas corpus issued by Chief Justice Taney by himself, not by the full Supreme Court. We've never seen a president who said, okay, the Supreme Court has told me I have to stop doing something, I'm going to keep doing it. And I think the critical point at that point is we would have a breakdown, Congressman, not just in the rule of law and the separation of powers, we'd have a breakdown in the courts because the executive branch depends upon the courts when it's the plaintiff to prosecute crimes, to bring civil enforcement action. So I think, the point of no return would be a point when the courts are no longer willing to even do the executive branch's regular business because the executive branch won't abide by the court's judgments.
In your testimony, you briefly described 4 areas that this committee should be focusing on right now to address the unprecedented power grab by President Trump and Elon Musk, or maybe I should put that in reverse order. Can you please elaborate on these suggestions?
Sure. I mean, it seems to me that this committee, both historically and currently, has both the power and the mandate to engage in rigorous oversight of what the Department of Justice specifically is doing, of how the executive branch is complying or not complying with the various statutes, of the firings of inspectors general, of the firing of the special counsel Hampton Dellinger, who is the the head of the whistleblowing agency within the federal government. This committee has the power, of course, to consider whether legislation should be proposed, to rein in some of these claims, to backstop existing statutes, or perhaps even if the majority is so inclined to authorize what the president is doing. But the point, I think, Congressman, is is that what we have seen over the first 3 weeks is the president suggesting that this committee and all of Congress is completely unnecessary for him to do what he wants to do. And so whether it's through oversight hearings, whether it's through withholding legislation, whether it's through passing legislation, whether it's through the bully pulpit that members of this committee on both sides are so skilled at using, it seems like there is a much more important story to tell about what is happening right now to the separation of powers in this country than the admittedly important stories of my fellow witnesses. Those are all problems, but what we're seeing is a structural attempt to reallocate power, the likes of which we've never seen before, and that's where I think this committee has a responsibility.
Mr. Smith has argued for an independent judiciary. If we allow the Trump administration to skirt court orders, does the independent judiciary really function?
So I guess I am one congressman who still thinks that the line is holding. We have more examples historically of what I would call slow walking compliance with court orders by the executive branch, the likes of which seems to be happening right now. I would not put it past the possibility, Congressman, that part of the lack of compliance we're seeing is because of incompetence, not malice. And so it seems to me that we are not at the point yet where the executive branch is affirmatively refusing to comply with federal court orders.
And if we get to that point?
Then I think it would be incumbent upon this committee to pursue articles of impeachment. And I would hope that there would be sufficient members of the majority who would think that that was part of their constitutional responsibility, that the politics of the moment would give way to the politics of our constitutional order.
Thank you, Mr. Chairman. Mr. Chairman, I yield back.
Gentleman's time has expired.
Thank you, Professor. Mr. Chairman, I yield back.
Gentleman's time has expired. Now recognize the gentlewoman from Wyoming for 5 minutes.
Thank you. I guess I would take your testimony a bit more seriously, Mr. Vladeck, if you actually had ever complained or shown any light on the Biden administration's efforts to forgive the student loans in violation of the law and court order. Ms. Wade, I appreciate your passion for this issue. It is something that is incredibly significant, and I think the caterwauling that you hear on the other side is what happens when you shine a light on the scurry little things that live under most rocks that most of us find rather disgusting. The 2024 version of CEI's 10,000 Commandments found that federal regulations' total compliance costs and economic effects are at least $2.117 trillion annually. U.S. households pay an average of $15,788,000 annually in a hidden tax, which consumes 17% of income and 22% of household expenses. The Biden-Harris administration imposed over $1.7 trillion in cumulative regulatory costs on the economy, surpassing all predecessors. The issue of overregulation in this country is absolutely real, and it is people like you that are affected, regardless of whether Mr. Vladeck feels that you should have a voice in these proceedings. Mr. Smith, I want to turn to you because I think people need to understand what ALJs, administrative law judges, and administrative law courts actually do in this system. If you want to talk about unconstitutionality, Article 3 establishes an independent judiciary to protect citizens from loss of life, liberty, and property without due process of law. Over the last 50 years or so, a variety of federal agencies have created their own court systems, led by administrative law judges. It would come as no surprise to no one that agencies enjoy outsized success in proceedings before these ALJs. After all, they're wearing the same jerseys. They're on the same team. In Article 3 courts, as provided by the Constitution, the SEC only wins about 58% of its cases. And between fiscal year 2011 and 2014, the SEC, however, won an average of 90% of its cases in front of ALJs. The FTC, who you went up against, wins not over 90% of its cases before its own ALJs. Yet Lena Khan, who was the head of the FTC under the last administration, lost almost every single case she ever brought before an Article 3 case. Or an Article 3 court. When Axon was forced into the FTC Administrative Law Court, or ALC, proceedings, were you provided with the same protections and rights you would expect in an Article 3 court, such as due process, the right to a trial by jury, that sort of thing?
Absolutely not. No, it was a foregone conclusion. Frankly, it was described to me by my attorneys as hopeless. There was a 0% chance over the previous 20 years of getting a fair trial. And even once we came out, if it went to appeal, the appellate process would be only reviewing the FTC's version of events. They get to write the entire record, and you never get a day in court. Maybe you get an appellate review to see if they made an error in the law, but we would never have gotten a chance for an independent arbiter to hear our claims.
I would think that the people on the other side of Mr. Vladeck would be concerned about the violation of constitutional rights that you just described, but apparently they're more concerned about protecting the unelected bureaucrats and their ability to send millions of dollars to things that we don't want to pay for, such as trans comic books for people in Peru. The FTC enjoys over 90% success rate in proceedings before the ALJs, as we just talked about. And what I understand is that you were forced to spend $20 million defending yourself in these FTC proceedings. Having been an administrative law attorney for many years, I describe this as the process is the punishment. Would you agree?
The process was a heck of a lot of punishment. However, it was nowhere near what was being threatened. For a $13 million acquisition, the government was basically looking to seize $1 billion worth of intellectual property, as well as half our customers, and an unlimited liability. So the process was terrible, but we had to go through it because the alternative was even worse.
As you likely know, in this Congress, I have introduced the Seventh Amendment Restoration Act, which provides Americans with the right to remove their cases before an ALJ to an Article III district court. Do you think that that is something that would have helped you in pushing back and fighting back against the FTC in these horrific proceedings?
I have to say that that proposal is beautiful in its simplicity, and I think it actually would fit what we've all talked about, the system of checks and balances functioning properly, that an American should be able to say, my goodness, if I have the government coming after me, may I please have an independent judge where I can plead my case and have a chance of prevailing.
Thank you, Mr. Smith. Thank you, Ms. Wade. Thank you, Dr. McLaughlin, for being willing to come here and expose this horrific situation, this horrific administrative situation that we're dealing with. I yield back.
All right, now that we have watched the full exchange, here is my honest take. The hearing opened with Professor Vadak raising the possibility of a constitutional crisis if President Trump ignored federal court orders. That is a serious claim. The idea that impeachment could be on the table is not small talk. That is escalation. But here is what caught my attention. Professor Vadak also admitted that we are not currently at the point of outright defiance. Professor Vadak described what appears to be happening as slow-walking compliance, and even suggested it could be incompetence rather than malicious refusal. Yet impeachment was still introduced into the conversation. That feels premature. This is where Harriet Hageman made an important move. Harriet Hageman questioned credibility and consistency. Harriet Hageman asked why there was not the same level of alarm when the Biden administration pursued student loan forgiveness after the Supreme Court struck it down. Whether someone supports or opposes that policy is not the issue. The issue is consistency. If constitutional limits matter, they have to matter every time, not just when it is politically convenient. Then the conversation shifted to something even more significant: administrative law courts. When Mr. Smith described his experience fighting the Federal Trade Commission inside its own administrative court system, that was eye-opening. According to testimony, the FTC wins more than 90% of its cases before its own administrative law judges. In contrast, the agency's success rate is much lower in Article III federal courts. That raises real due process questions. Mr. Smith said he spent about $20 million defending a $13 million acquisition dispute. That is not just litigation. That is financial pressure. That is leverage. And as Harriet Hageman pointed out, sometimes the process itself becomes the punishment. Harriet Hageman's Seventh Amendment Restoration Act is simple in concept. It would allow Americans to move their cases from agency-controlled administrative courts into independent federal district courts. That does not sound extreme to me. It sounds constitutional. The Seventh Amendment protects the right to a jury trial in civil cases. Article 3 establishes independent courts. If the federal government brings an action that could financially cripple someone, asking for an independent judge and full constitutional protections seems reasonable. What stood out most in this exchange is that Harriet Hageman was not defending chaos. Harriet Hageman was defending structural fairness. There is a difference between respecting the judiciary and empowering bureaucratic systems that operate with limited external checks. The impeachment talk may grab headlines, but the deeper issue here is power. Who holds it? Who checks it? And do ordinary Americans truly have a fair chance when facing federal agencies? From my perspective, Harriet Hageman brought the focus back to constitutional balance instead of hypothetical crisis language. That is my take. Now I want to hear yours. Drop your thoughts in the comments. Do administrative law courts protect citizens, or do they protect agencies? This has been Audrey with Congress Lens. I will see you in the next one.